Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 195. We're doing all right at the moment for sending these out one every day, although I am, to be honest, not entirely sure the pace will continue all the way through until Christmas time. Anyway, I wanted to talk about a case dealing with the ability to challenge an ACAS COT3 form and whether the settlement was valid and binding. The judgment has a number of salutary lessons in it, and although I think it will be relatively rare that such a case will make its way through the courts, I think you certainly don't want to be caught out when these cases arise. So this case is Mrs. Cole and Elder's Voice. This was a successful appeal from an employment tribunal decision. Let's lead with a plot spoiler for once. Well, facts are a bit complicated, but it's worth getting into them because of the nature of the findings. The starting point is that Mrs. Cole sued her then employer, Sanctuary Housing Association, in 2017. She was employed by them between November 2011 and August 2017. With effect from 1st September 2017, a new employer, Elder's Voice, took over the services that had been provided by Sanctuary under the transfer regulations. She was made redundant at some point shortly after the TUPE transfer. However, that left her tribunal claim against Sanctuary outstanding. Her tribunal claim made its way through the system, and she eventually added Elder's Voice as a second respondent. Eventually, the case settled and an ACAS COT3 form was signed in December 2017. Crucially, the settlement was concluded between the claimant and Elder's Voice. Elder's Voice was identified as her employer and it agreed to pay a certain amount of money. This is in full and final settlement of any claims against Elder's Voice. However, there was a sentence at the end of the full and final settlement clause that read, quote, "For the avoidance of doubt, Sanctuary Group is not an associated company of the employer," unquote. The claim then continued, I assume because Mrs. Cole viewed herself as entitled to carry on the proceedings against Sanctuary. Remember, she'd originally been suing Sanctuary and Elder's Voice had been added in. Elder's Voice then applied for a preliminary hearing to decide whether or not the case could proceed at all, given the existence of a COT3 form. Well, Mrs. Cole and her advisor belatedly appreciated that Elder's Voice were responsible not only for any claims she might have directly against Elder's Voice, but were also responsible for the claims against Sanctuary, which had transferred under TUPE. So, she submitted to the Employment Tribunal that the COT3 had been based on a misrepresentation to her, and so it was void, or that the respondents were stopped from relying on the COT3 form. The tribunal judge was asked by her to consider in the course of this application some without prejudice material that had passed between the parties when negotiating the settlement. During the tribunal hearing, the representative for Elder's Voice objected to the Employment Tribunal judge looking at the WP material, and the tribunal judge agreed it could not do so. The tribunal judge took the shortcut of saying that the COT3 document existed, it covered the claims, he couldn't go behind the ACAS document, and that she had no basis for challenging it. Although there were further attempts by the claimant to get the tribunal judge to alter his mind, these were unsuccessful, so the case went up to the AT. The basis for the claimant's appeal was that the Employment Tribunal judge had erred in law in deciding that the COT3 form was valid. It was void because either there was a misrepresentation or the respondent was stopped from denying that it permitted claims against Sanctuary as a result of representations the second respondent, Elder's Voice, had made during the without prejudice discussions. On that basis, the claimant argued it was an error of law for the tribunal judge not to have looked at the without prejudice material before deciding whether the COT3 form was valid. Well, the AT started with the general position under the law of contract. The AT started with the general position under the law of contract, Without prejudice documentation will of course normally be excluded, but a court can look at without prejudice material if it is argued that an agreement apparently concluded between the parties during the negotiations should be set aside on the grounds of misrepresentation. Similarly, if the without prejudice material gives rise to an estoppel, then the material may be considered. And additionally, if the without prejudice material was going to be part of the factual matrix or surrounding circumstances for ascertaining the true construction of the agreement, then again, without prejudice material can be reviewed. Next up, the EAT confirmed there was no reason in principle why a COT 3 agreement was to be treated differently from any other form of contract, and the EAT in this context pointed to the 2010 case of Industrious Limited and Horizon Recruitment, in which the EAT had made clear its view that the same grounds existed for a COT 3 form to be declared void that existed for any other contract. Although a recent case, the Patel case, earlier this year had cast some doubts on the industrious approach, the EAT decided that the Patel case had been wrongly decided because it had not had all of the relevant authorities drawn to its attention, so it should be ignored. So, claimants over the first hurdle. The next question was whether the material in fact showed there was an arguable case for misrepresentation. Here the court went through the correspondence between the parties' advisers. Matters were slightly complicated by the fact the claimant was being represented by a barrister who, unknown to her, and of course the other side, had in fact been disbarred from practicing. As I say, I'm not proposing to go into that issue here because obviously that's a pretty unusual set of circumstances, but it was a complicating factor. Anyway, the without prejudice material started after she was placed at risk of being made redundant by Elder's Voice. Her representative, apparently not appreciating that Elder's Voice would have inherited liability for the claims against Sanctuary under TUPE, wrote to Elder's Voice asking why the Sanctuary claim had been sent to them by the tribunal. The tribunal pointed out this was a clear flag that the representative was unaware of the impact of TUPE. The lawyers acting for Elder's Voice stated in response there was no relationship between Sanctuary and Elder's Voice, that the business transferred under TUPE. They said that, and went on to state, quote, Elder's Voice accepts no liability in terms of any claims that Gloria may have that occurred before 1 September 2017, unquote. They went on to say that Elder's Voice would not comment on Sanctuary's liability, and it would be inappropriate to write on their behalf, and that Elder's Voice were only attempting to settle any claims that Gloria may have against Elder's Voice, and on that basis they felt that their offer was a reasonable one. Correspondence continued with the claimant's barrister, referring to keeping alive the litigation against Sanctuary. Eventually, the COT 3 was concluded, and at the last minute, at the request of Mrs. Cole's representative, the wording was added to confirm that Elder's Voice had no connection with Sanctuary Group, i.e. it was not an associated employer. This was, of course, in the context that the settlement agreement said that they were settling claims against Elder's Voice and associated employers. Anyway, Elder's Voice responded to say the point was agreed, and they added the wording, as I said above, that it was not an associated company. Well, the EAT was pretty critical of the respondent solicitor's correspondence, and I should say I am summarising it, so some of the nuances of the correspondence may well be left out at this point, but the EAT looked at the representation made in the exchanges of letters, that there was no relationship between Sanctuary and Elder's Voice. In the EAT's view, that was arguably wrong, because they were a transferor and transferee under TUPE, which was the most important relationship they could have in the context of this claim. The representation to her by the lawyers that Elder's Voice accepted no liability in terms of any claims for 1 September 2017, the TUPE date if you remember, was also wrong, the judge said. The judge pointed out the case for Elder's Voice at the hearing in the EAT was now that it was responsible for claims occurring before the TUPE transfer date, because those claims were covered by the settlement of all claims against Elder's Voice, i.e. now what they were saying was flatly contrary to what they were apparently telling the claimant at the time. It was also pointed out it was arguably a misrepresentation to say that they couldn't comment on Sanctuary's liability, the judge said, given that Elder's Voice had inherited that liability. Similarly, it would have been entirely appropriate for Elder's Voice to write letters about the liability that it inherited. It was also asserted to the claimant's representative that settlement would not affect potential claims against Sanctuary Housing, which, in my terms, is accurate only in the most technical sense, because she didn't have a claim against Sanctuary at that point in any event, because it had TUPE transferred. Anyway, the request for clarification that Elder's Voice had no connection with Sanctuary Group, and for that wording to be included in the COT 3, was met with a response from Elder's Voice's lawyers, confirming that wording would be added to that effect, quote-unquote. Once again, the judge felt that this was misleading, because there was a connection with the Sanctuary Group, and the wording added was not to that effect because of the impact of TUPE. The judge felt that describing Sanctuary Group as not an associated employer with Elders Voice was not, in the context of these negotiations, with a barrister who had clearly misunderstood the impact of TUPE, a term of art. It was simply a term that whether or not there was a relationship between them, and that was at least arguable because of the TUPE transfer. In short, the judge accepted the correspondence was arguably one or more of a series of misrepresentations by the lawyers acting on behalf of the respondents, and as such they could invalidate the COT 3 form or affect the way in which it was interpreted. Anyway, it's important to appreciate the judge at this stage has not definitely held the agreement is void. He has merely given permission for the claimant to rely on the without prejudice material to make good her claim that she should be allowed to pursue the sanctuary claim against Elders Voice. Standing back from that, I think 2 points are, really important. First, the ability to overturn a COT 3 form, or indeed a statutory settlement agreement, is an important one. It won't come up very often, but advisors will all have seen examples of buyer's remorse, where a claimant has settled a claim for a sum of money, then shortly afterwards thinks better of it and seeks to reopen things. Most times, that doesn't get much further than correspondence. But here, the claimant, clearly feeling she'd been wronged, was not going to be easily dissuaded from pursuing her claim. Now, the matter's gone back to the Employment Tribunal, so it'll be interesting to see what they do when they look at the facts in more detail. However, this brings me on to the second point. The solicitor's correspondence, seen from one perspective, might be thought of as strictly accurate, but, in the view of the EAT judge, giving a misleading impression. I have a smidgen of sympathy. I think the employment judge, the EAT judge, I should say, had the benefit of looking at this with hindsight. But, they are right to say that from one perspective, neither Sanctuary and Elders Voice were associated companies. And I think the judge was probably straining slightly to say, in circumstances where the claimant was represented by an allegedly expert representative, the existence of a TUPE transfer means that denying that one company is an associated company of another, it means denying any relationship at all. Maybe it's a bit of a strain. It's arguable, and that in fairness to the EAT, of course, was what they were evaluating. On the other hand, it's difficult to avoid the impression that the claimant and advisor clearly did not realise the effect of TUPE was to transfer claims to Elders Voice, and that Elders Voice was quite happy to leave them in the dark about the point. This is, I think, where the matters have gone wrong for Elders Voice. It's possible they did not look to make it clear that the existing claim was going to be fully covered by the settlement agreement, because they knew the claimant wouldn't agree to that. If that's true, and I emphasise I only know what I've read in the judgment, that's obviously quite a dangerous road to take. I think that the general rule that comes out of this is you need to be very careful in your correspondence with the other side, particularly if there's a litigant in person, that you don't make any statement which is not appropriately qualified and which mustn't overstate the position. It's much easier to be said than done. We've come across this of course, in connection with cost warning letters to unrepresented litigants. There's nothing to say you can't write a letter advising an unrepresented litigant they're at risk of paying your costs, but you better be extremely careful when you do it and make sure you're not overstating either the tribunal's powers or the likelihood of a costs award being made against a claimant. I do think it's quite tough for the respondents in this case, given they didn't appreciate the barrister who was representing her had been struck off, but the judge did say they would have been aware from the correspondence that he clearly didn't appreciate the impact TUPE. So the upshot is that, whether by design or accident, the respondent had appeared to put one over on the claimant in relation to the claim against Sanctuary, but the upshot in reality has been considering more legal expense and time spent before reaching the point where the COT 3 form may provide no defence whatsoever to Elders Voice in relation to the Sanctuary claim. I think the moral of the story is to be very clear about the impact of any settlement, so it's plain on the face of what is covered and what is not covered. If you feel unable to do that because you don't want to flag something up to the other side, then I think you need to be very careful. And if you've made any representations in that area, there must be a real risk whether the other side, when they find out about the point, that they're able to then file a claim to overturn the COT 3 or settlement agreement, or construe it in a way which allows the relevant point still to be argued. Anyway, thank you very much indeed for listening, as always. I hope that was helpful. We'll have another podcast episode going out very shortly. And I hope everyone stays safe and out of harm's way, and it only remains for me to confirm that no members of the British Cabinet were harmed or mistreated in any way during the making of the podcast. Take care.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.